Welcome, everyone, and thank you for joining us today. My name is Richard Mollett. I'm with the Long-Term Care Community Coalition. As you can see on your screen, we have some virtual meeting tips. Please, again, put any questions that you have in the Q&A. We will try to get to them at the end of the program. If you have comments, if you want to chat with other participants, you're welcome to use the chat function for that. And if you have any technical issues, please do put them in the chat, and we will endeavor to help you. A little bit about LTCCC, for those of you who are not familiar, we are a nonprofit, nonpartisan organization entirely dedicated to improving care and quality of life for residents in nursing homes and in assisted living. Most of our work historically, we were founded in 1989, has focused on policy research and analysis. Those of you who are familiar with our work know that we do a lot of work on the rules and the regulations, the law, and the data, which showing the extent to which nursing home, in particular nursing home residents' needs are being met, and the industry is operating in accordance with the federal rules. We use our findings from that research and from the data to undertake systems advocacy. And over the past dozen years or so, we've been doing more and more public education, such as programs like this. We have a dementia care advocacy toolkit on our website. We have a lot of family council resources, and happy to help people with their family council issues. And we're also the proud home to 2 local long-term care ombudsman programs. Visit nursinghomes411.org for more information. All of our resources are free to use and share. And without further ado, today's program, I'm really excited. Its title is The Dangers of Understaffing and the Need to Litigate. And we have 2 very special guests today. Kelly Bagby is the Vice President of AARP Foundation Litigation, and she manages the office's work related to health, hunger, housing, and human services. We've worked with Kelly for many, many years and really admire her work and those of the entire office. Joining us today also is Benjamin Davis, who is new to me, but really excited to meet him. Benjamin is a senior attorney for AARP Foundation Litigation. He focuses on unfair employment practices and consumer issues, and he represents older individuals in both class action and individual lawsuits across the country. So without further ado, I am going to stop sharing and hand it over to Benjamin and Kelly. You can see your screen.
Hi, thanks so much for having us. We are thrilled. Can you all hear me?
Yes.
Okay, great. So we want to talk to you today about an issue that's near and dear to our hearts. We do a lot of work around protecting long-term care residents in all settings, but we're here today to talk to you particularly about the work we're doing in assisted living and nursing facilities. And I'm very proud to have Benjamin Davis here, who has really been a huge influence over our casework. He's going to talk to you about one of our cases, and I'm going to talk to you about a couple others. So I'm going to talk a little bit first about what is AARP Foundation Litigation. We're the charitable nonprofit arm of AARP, but we're a small litigation firm within AARP Foundation. We're small but mighty. We focus on civil rights cases. I'm going to talk to you again about the work that we do for people in long-term care. We do a lot of work fighting abuse and neglect in nursing facilities. We also promote the ability of people to avoid all chemical restraints. We ensure that residents facing illegal and involuntary discharge can remain in their facilities. And we fight disability discrimination so that older people can live where they most want to live, which is in their own homes and avoiding institutional care. So as a natural outgrowth of this, we've started to focus on some of the work around broken promises when people are coming into facility and they are promised that they'll have certain level of care, and that promise is false. The reason it's false is because these facilities are grossly understaffed and the promises are incapable of being kept. So we're going to talk a little bit about that. So we advocate for systemic change in federal courts and state courts. It's harder, obviously, for us to do work in state courts because we are based in DC, but we do work in federal courts quite often. The 3 cases we're going to focus on today are in federal courts. Excuse me, but we are really especially focused on changing the circumstances that give rise to poor care. We're a team of 16 attorneys, 4 paralegals, 3 legal assistants, and we focus on cases all over the country. So even though we're 16 attorneys, that's a lot of area to cover. So we're going to talk a little bit now about this legal theory. Ben, do you want to pick this up?
Good afternoon, everyone. The legal theory that we focus on that we see that's always been a big problem is that families want their loved ones to be safe. They want their loved ones to be cared for, and that's why they look at an assisted living facility, because they offer a lot of things that nursing homes don't. And that's just basically assistance with daily living. And the problem is that when people come, these nursing homes promise them that they will be able to provide sufficient level of staffing or to meet their needs. However, unfortunately, that doesn't happen. And one of the primary reasons why that does not happen is that because people are always under the mistaken belief that people will get individual care for their actual loved one. And sometimes they don't really understand the dynamics about the fact that the staffing is not devoted specifically to that loved one in particular, but to all the residents of the population. And that's the biggest issue that we see. So even though one person might say, oh yes, we'll be able to meet your needs, we look at collectively at the whole staff, that's almost impossible. So they make that promise, get people in the facility, make them promise that they will keep on assessing their needs. And unfortunately, that does not happen. And so that's when the biggest focus on litigation in order to really rectify that. And there's some important cases that we're doing now that's really helped with that. I'm currently working on a case in West Virginia, and that one's a smaller case. It has 4 assisted living facilities. But keep in mind, even though it's a smaller case with 4 assisted living facilities, it's probably about 400 people total in the class. And with that, and the same thing that we see all the time with these defendants, they always get a focus on our individual plaintiffs, what their medical history was before they entered the facility, try to distinguish them so we can't bring this matters on a class action. However, the law is pretty good in this area, meaning that we focus on the defendant's conduct at the class certification stage. And because we focus on the defendant's conduct, it really eliminates the need for the individualized assessments or individualized inquiry. Those are key terms that we see in all these types of cases. So therefore, when we litigate these matters, we go into it knowing that, of course, everyone's going to have different care needs, but that is irrelevant, and we make that point clear to the court. And even though one of the cases I was talking about is smaller, that's all for class wide, because I know there's some bigger ones that we're working on as well.
So thanks, Ben. So the cases, now I can't get it to turn again. Oh, there it is. All right. So Ben mentioned West Virginia, and he's going to talk in greater detail about that. We also have a class action in Illinois against a chain that has about 40 facilities in Illinois, but we're suing 6 of them. We also have a case that's based in Tennessee federal court, but it's actually about the Illinois case is against Alden Group. The Tennessee case is against Brookdale Senior Services, and it's based in Tennessee. Well, Brookdale's based in Tennessee. That's why we sued in Tennessee. But that case is actually about all assisted living facilities that Brookdale runs in both Florida and North Carolina, which is about 210 facilities. So that's obviously a huge class action. And it is, there's a lot of work being done to try to address these systemic issues. As Ben said, we focus on what the facility is doing wrong, not the way that each of the residents has suffered neglect. So that would be more like a malpractice case. Our cases are really about how do we force these companies to change their practices and actually adequately staff. These are very novel arguments. This is a novel legal theory we are using in these cases because we're using a consumer protection statute. The consumer protection statutes in each of these states allows for people to recover for actual injuries when somebody promises them something and doesn't deliver it, or fails to tell them that the services aren't going to be provided as they expect. So in every assisted living and in every nursing facility, as you guys know, there's a residency agreement that lays out the promises to the resident. In Illinois, the residency agreements also include arbitration clauses saying that if you have a dispute with us, you have to arbitrate. In Tennessee, in the Brookdale facility is the same, and in West Virginia, it's the same. In Illinois, we have moved to invalidate all of the arbitration clauses because the Alden facilities arbitration clauses say that you, as a resident, can only arbitrate if you have $1,400 to spend on arbitration. Well, these are almost all Medicaid beneficiaries. This is a nursing facility case in Illinois. These are all Medicaid beneficiaries, and they don't have $1,400 sitting around. So our argument is that this basically makes the only way to fight back inaccessible to the vast majority of the residents because they don't have this kind of money that would allow them to fight back. And because they cannot file lawsuit in court, they have no recourse. There's nothing they can do. So we are hoping this in this month, we're getting a decision on whether or not our request to the court in Illinois, and this is an Illinois state court, if the Illinois court will allow us to just invalidate all of the arbitration agreements in that case. We're also trying to survive what's known as a motion to dismiss. So this is a hotly contested case. The industry in Illinois has hired one law firm to fight us on this one case because they're so nervous that we will be, perfecting this theory. And it will end up being something that every nursing facility in Illinois, which there are many, will be facing because there's a lot of understaffing in that state. So we've been investigating that case for many years before we filed it. We filed it about a year ago. We coincidentally happened to file it around the time that the Biden administration announced that they were going to make major reforms for long-term care. So that was great for us. But it also has been a galvanizing force because I think it really showed that we managed to, one of the other things, because we are housed within ARP, we try to secure as much press for any case we bring so that we can get as much education out there about the perils of understaffing. And so part of the litigation is tied to public education in every one of these cases. And so it's really critical to us to have transparency about the practices. And again, these are cases brought as consumer protection cases. So we want people to understand if this is wrong, you should not be lied to about the staffing levels when you come into one of these long-term care facilities. In the assisted living facilities, people pay a lot of money to get in the door to one of these facilities. And so they're basically for the commitment to be in the facility, they're paying thousands of dollars just for the joy of walking in, and they don't get that money back, even if they leave quickly. I'm going to turn to the Brookdale case for a minute. The Brookdale case is now, we've moved for class certification in that case. And we just moved like last week. It was a huge ordeal, as you can imagine, 210 facilities, many tens of thousands of residents. But what we're trying to get at is the same like systematic understaffing that is what we've alleged against Brookdale, and that we believe that it's done at a corporate level. In each of these cases, we believe the decisions to understaff are done at a corporate level, and that proliferates down to the facility level, and the facilities don't really have a lot of discretion to go against what the corporations are saying. So that helps us, because in class actions, you want one uniform thing that you're fighting against. We'll see how the decisions work out in each of these cases. But from our perspective, it's really critical that we are fighting for, not just, we're fighting for systemic cases against these chains, but we're also fighting for systemic change across the entire industry, because this is not, as you guys know as well as we do, this is not limited to the targets we've identified. This is a problem that residents in long-term care are facing all the time. Ben, do you want to take a minute and talk about the West Virginia case? I'll turn this off.
Well, what's really sad about this, as Kelly talked about, I was surprised coming here how much money people are paying out of their pocket. And when we talk about thousands of dollars just to initially get into the community fee, some cases it could be $3,000. After that, we're talking about $5,000 for personal care fees. So therefore, that's important because we want to bring these matters under class action. We have to have a specific injury, and that specific injury in these types of matters, the economic injury. And our theory of the case is that our people would not have placed their loved ones into the actual resident if they would have known that it had been understaffed. And so that's our theory. And like we said, a novel theory, but a good theory, and one that we believe that is going to be successful. One of the biggest pushbacks that we get in these types of matters that I'm noticing is, why, if the care is so bad, why is your loved one still there? I just talking to this, investigate a lot of people, closeness is one of the biggest thing in terms of proximity. So even though they could essentially take someone out and put them someplace else, people still want to be able to visit their loved one. The particular case I have in West Virginia, they were so disappointed in care. Not only are they paying thousands of dollars to the actual assisted living facility, but also paying a private babysitter to be with the resident the whole time, just because the family is not going to be able to be there 24 hours. So that is one of the biggest things that the defendant will try to say, why did you not move? But we have to keep in mind, you have to stay practical. Is it really even an option to move? So that's one of the biggest things that we look at as well. And also, at ARPP, we want to help as many people as we can. And that's why we bring these matters on the class matter. And following up a little bit of what Kelly said, the West Virginia case is a little bit different because they all have arbitration clauses. Some are different and some are the same. So in this particular matter, we strategically picked the arbitration agreement that the Supreme Court already found to be invalid. Now, this particular strategy, it seems like we could maybe gotten a few other residents who signed another arbitration agreement, but with these types of cases, to keep it clean and to keep it more organized, the court really looks at that fact, and eliminating that arbitration issue is huge. And in this particular matter, we're moving for class certification on October 23rd. And I feel really good about that aspect because the class is easily discernible. A lot of the cases that, Kelly was just discussing, there are up and down arbitration agreements, who's really in there. So, it cuts both ways. We can help more people with the arbitration agreements if there are more, but also get into a class, realistically, it's best to get one that everyone's on the same page to eliminate that issue.
So more on the arbitration agreement in the Chancellor case. We've sadly been litigating this case for about 6 years, and we went to the West Virginia, the defendants drove us to the West Virginia Supreme Court. We got an early decision saying that their arbitration agreement was invalid on its face because it incorporated the American Health Lawyers requirements. So the American Health Lawyers say you have to have an arbitration agreement that stands alone and it has all these other procedural requirements. Well, this one didn't meet any of them. So on its face, this arbitration agreement didn't meet the internal procedures it was saying it was required to meet. So we took it all the way up to the West Virginia Supreme Court, and the West Virginia Supreme Court agreed with us and threw out all of the AHLA all the arbitration agreements that had that provision. So that was basically 4 years worth of arbitration agreements that were just thrown in the trash. And so that freed us up to have a much larger class than in these cases where we have to figure out who has an arbitration agreement, who doesn't, is it valid? Did a power of attorney have the authority to sign it? Was it the right person that signed it? Was it not the power of attorney? So some of these things get a little weedy, and but it's something to think about as ombudsman and family members, that an arbitration agreement does not have to be signed. A nursing facility and an assisted living facility can't obligate you as a condition of being admitted to sign an arbitration agreement. And we can do another whole training on the ways to avoid and to train families to just X out arbitration provisions so that your family member won't be bound by them. But it is critical, because if you ever want to be able to vindicate the rights of one resident or a class of residents, you have to deal with these arbitration agreement provisions, unless and until Congress throws them out, as we've been advocating and as Long-Term Care Coalition has been advocating for many years. All right, so I don't know why this thing won't. Okay, here we are. So I'm going to change gears for a second and talk about trying to keep people out of long-term care facilities if we can. So the Supreme Court had a really landmark case called Elsie versus Olmstead in 1999, where the Supreme Court declared that keeping a person in an institution unnecessarily, if they have a disability, is per se discrimination. If they can live in the community and they don't want to live in an institution and they're on Medicaid, then or even if they're not on Medicaid, the Supreme Court has declared that a state is obligated to change the way they provide services to enable people to live in community settings. So it's called the Brown versus Board of Education for people with disabilities. It's such a landmark case that has really changed the lives of people with disabilities for these 3 decades. But the problem is nursing facility residents were left behind until we started bringing these cases to free nursing facility residents from long-term care if they don't want to live there. If they want to live there, that's their right. But if they don't want to live there, then our job is to bring class actions to get them out. So in 2010, we brought a case against the District of Columbia. And what we were seeking was basically a system of case management, of transition assistance to help people in nursing facilities to rebuild their lives so they could leave nursing facilities and go live in the community. And a lot of times what we found when we go into these facilities is people literally had no idea that there was a community-based system. They didn't know that home care existed. They didn't know that they could get their activities of daily living met in their own home instead of being in an institution. So we brought this case in 2010. It's now gone up to the DC circuit twice. We've gone back to have 2 trials, and now we're currently waiting for a result from the last trial that we finished in 2021. But the home care and community-based services are precisely the same services that people get and need when they go into assisted living and nursing facilities. It's help moving from their bed to a wheelchair, help with eating, help with toileting, help with dressing, help with bathing, help with adaptive equipment if they need it, and help positioning people to be able to get, in and out of different positions, their bed or their wheelchair. It's also transportation and respite and employment assistance. It's also all the kinds of things that people need to live in their own homes. And these are all things that are available through home and community-based waiver programs. But people on many states are over institutionalizing people when they really should be using Medicaid dollars to serve them in home settings. So the Brown case, as I said, finished its second trial in December 21 in the DC federal court. We had a trial the first time in 2016. We lost, we appealed, and the DC circuit agreed with us 100%, reversed the whole case, and that's why we had to do a new trial. And we're hoping for a big win on that one. So we also have another case in New Hampshire that is another Olmstead case, in this case, we're trying to keep people who are in home and community services in their own homes, to keep them safely there so they can remain there. Unfortunately, the state is administering its home and community-based services so poorly that hundreds of people, like many hundreds, like 700 people each month, don't get the services that they need. And that's placing them at risk of going into nursing facilities and hospitals, and also risk of deteriorating and death. I mean, it's quite serious. These are people with very complicated chronic medical conditions, many of them multiple conditions. And when they are supposed to have, let's say, 40 hours of services, home, like real ADL assistance in their home, and they don't get but maybe 5 hours of that, it's incredibly dangerous. And also incredibly illegal, because it's placing them at risk of violating their rights under the Americans with Disabilities Act, which is what Olmstead is enforcing. So this is the case. It's called Price. Well, now it's not called Price. It's called Fitzmaurice versus DHHS. And we are litigating that case with Disability Rights Center of New Hampshire, the law firm of Nixon Peabody, and the New Hampshire Legal Assistance Program. I should say, oh, excuse me. I don't know what just happened, but I should say that the Brown case, I'm going to just stop sharing for a second. The Brown case was brought with the Protection Advocacy Program in DC, as well as the law firm of Arent Fox. And I think these are cases that if you all have facts on the ground that you really want us to, that you want to have us help you to construct a lawsuit, or have us help to really explain why something is violative of both Medicaid or the ADA, we're happy to do that. I want to give Ben a chance. I've lost the PowerPoint, so Ben's going to have to do it from his own slides. But Ben also came to us as an expert in bringing wage and hour cases on behalf of people like home care workers, which we have to replenish the stock of people who want to do this work. And so Ben's going to talk a little bit about his strategic work to do that.
My background, for about 10 years, I was at a plaintiff's firm in Baltimore, and my focus was employment discrimination. And it was interesting coming here with those dynamics, because there's an independent contractor element that I'm noticing that a lot of violations for people that are older people. So it's different at ARP because we want, older people to live their lives, and we want them to have a sense of independence. So in theory, it seems like things like being an independent contractor is something that will work out on their behalf. However, unfortunately, we've seen a lot of abuse in this particular area. Abuse meaning that they characterize these people as independent contractors when in theory they are employees. They have to schedule like employees, treat them like employees. The only downside is they don't get to pay that employees get. And when I say to pay, not specifically the amount of pay in terms of hourly, but all the benefits that you would get as an employee. And that really, really hurts older persons. I say that to say, keep in mind, if they're not an independent contractor, there's no benefits in terms of insurance. If they hurt themselves on the job, and in the particular care worker industry that you're in, it's very easy to hurt yourself on the job because, you're positioning a lot of older people. You're really trying to help them out. So it's sad when you see people doing all these things and not getting paid appropriately. And what is a deceptive trick that we're noticing in this industry? And typically, independent contractors that do home care work probably make about $20 an hour for independent contractors. If they're employees, they'll pay them approximately $10 to $12 an hour. So at first glance, people automatically think about and take the $18, not thinking about the, disability, the benefits, and all those other aspects. So we're seeing that, and we're really trying to change those industry practices. And along those same lines, which is interesting too, is that not only are we trying to change those industry practice in terms of helping the actual home care workers, this in turn has a direct impact on the care that the older persons receive, the people that they're actually caring for in their home. What's sad is because of they're not paid right. There's such a high turnover rate. And that really affects the older persons that are receiving care for them because they need a sense of stability. They want to be able to see the same person every day. And that's almost impossible with how things are set up right now. So that's something that is a twofold dynamic where we're helping older persons that are actually doing the work in hopes of facilitating the care of the older people that are on the other end of that work. So that's an interesting new aspect of litigation that we're doing here, and I'm very excited about that.
So, Haley, thanks. If you can move to the second to last slide. So here's the slide that describes what Ben is talking about. And I go to the last slide, and our contact information is there. So I urge you to contact us if obviously Richard and the Long-Term Care Coalition are extraordinarily well connected and can help people in your area to find attorneys that are happy to help them. But I do think we need to continue this conversation, particularly about how to rebuild the home care and nursing facility workforce. There's a lot of attention from the industry saying that it's impossible for them to get workers. And this is obviously untrue, because if you pay people, you train people, you value people, you're going to be able to get workers. So I think it's critical that we figure out ways to both force states and corporations to do better, but also that we think creatively about how do we really professionalize the workforce in this area so that people are paid well, they want to do the work, they're celebrated, they love coming to work, they're not going to try to avoid coming to work. But I think that's critical because the two things have to go together to cause real systemic enhancement and improvement for the people we work with. So I wanted to throw that open. I figured there's probably some questions. I think I saw some questions in the chat.
We have a lot of questions. Thanks.
Okay, so why don't we take the PowerPoint down and we can
Great.
go ahead and
I'll
answer some questions.
share my screen. Just a couple housekeeping items before we move. First of all, thank you both very much. It was just so interesting and there's so many points. I'm like, oh, I would love to even hear more about it. As you said, there's so many things where you could just do a program in and of itself. Before we go to Q&A though, and we have a lot of questions in the loop, I just wanted to let everyone know that on next Thursday on the 26th at noon Eastern, we're going to be hosting our next family empowerment program. It's going to be about family councils, Alzheimer's and dementia care, which are of course big issues for families of nursing home residents and of course for the residents themselves. So you can join us on Facebook or you can sign up for the Zoom meeting at the URL at the bottom, bit.ly/OCT-empower, EMPOWER. And then our next month's webinar will be on the 17th at 1 p.m. Eastern, and we are going to have a guest speaker, Ernest Tosh, who is an attorney from Texas, who I've been to several of his programs now. One, the New Jersey Long-Term Care Ombudsman Program, did a wonderful program with him. He spoke at the plenary last year at the Consumer Voice annual conference. He's just a tremendous speaker on a very complex issue, which is nursing home finances. And he really helps to put it in a way that is understandable about what is going on, some of the issues that Kelly and Benjamin talked about, the lack of staffing, et cetera. And really, the underlying causes are not what the industry is claiming, which the industry claims that they don't get enough money. In fact, we have a lot of nursing home operators that are making an awful lot of money while their residents are suffering. Oops, let me just see. Okay. Lastly, please head to Nursing Home 411 for materials from today's webinar to speak out in support of the minimum staffing standard and improving the minimum staffing standard that's been proposed by CMS. We have a lot of information, as some of you know, on our website about staffing and quality for every single nursing home in the country. We have state pages as well as national pages that you can search to find facilities in your specific facility, if you're in one or your loved one is in one, facilities in your county, your city, your state, or nationwide. So we welcome you to use those resources. And without further ado, I'm going to start with some Q&A. Again, we have a lot of questions here, and we'll take as many as we can. Our friend Dean Lerner from Iowa has a question. Actually, no, he has several of them. The first one is, I don't know if you know the answer to this, Benjamin or Kelly, but are there lots or few False Claim Act cases being pursued by the U.S. Department of Justice? And do you know if anyone's tracking that?
Yes. Hi, Dean. Yes, there are not, I wouldn't say lots, but there are False Claims Act cases that have been brought, and I think a couple have resolved recently with corporate integrity agreements. I think that we want to get more to them and try to encourage them to do more work in this area. I met yesterday, ironically, with Susan Lynch, who kind of oversees this for Department of Justice. And so I think that the more that we can sort of identify targets for them, the better off we are. But we're also working with, like in Illinois, for example, we're also working with state offices of Attorney General to try to get Medicaid fraud units to also look at these cases. And that's a great way to catapult up to DOJ if you can help the Medicaid fraud units in your state to really think about what are the biggest and worst kind of fraud cases. And fraud in the False Claims Act can be that the care is so bad that it shocks the conscience. That is a legal claim under the False Claims Act. So if you find those kind of circumstances, then by all means, and if you want my help to help package them, I'm happy to do that. But I think we do need to try to get more cases into the hopper.
Thanks so much, Kelly. I just wanted to quickly add to that on our website, again, nursinghome411.org, we have a link for people to help them complain or to connect to their Ombudsman program, their state health department, their regional CMS office. So if they're not getting the help they need from their state health department, they can go to the CMS regional office, the location as it's now called, and contact them with the complaint. But the reason why I mention this now is because we also have contact information for every state Medicaid fraud control unit. And part of the role of the Medicaid fraud control unit in virtually every state, it is located in the Attorney General's office. But if you look up, you don't want to go to our website, Medicaid fraud control unit or MFCU, and your state should get you the contact information. Every single state Medicaid fraud control unit takes complaints about abuse or neglect in facilities, including, and not only just facilities, but also in home care, et cetera, because we know that there's a lot of fraud, unfortunately, in home care as well. So thanks so much. I know, Benjamin, if you want to add anything, I apologize. Now we can move on.
No.
Okay, great, thanks. So Jan Shelley asked, have you used Section 1983 as a quote unquote way into federal court?
It's very, very difficult. We have in our New Hampshire case, we have a 1983 claim to enforce the Medicaid Act. Under Medicaid, you're supposed to get your services with reasonable promptness, and you're supposed to be able to get notice when you don't get your services, so you could potentially get a fair hearing to fight the state on that. But 1983 cases are important, but very difficult these days because the case law is not great. So that's why we try to pair up our 1983 actions with the ADA, because under the Americans with Disabilities Act, you don't need to use 1983. It has its own enforcement piece. So you can just cleanly go right after, either a public entity or a state who's discriminating. And again, discrimination is, it has a broad definition under these statutes. But I think for the purposes of corporations who are violating, basic consumer protection, 1983 wouldn't help you much. There is a case out in California where they brought, there's another nursing facility case again against Brookdale, where they brought a case under the ADA because nobody could get transportation to appointments. And so they brought this as an ADA case there. Again, kind of going around 1983. We'd love to, I'm always interested, there's fabulous case law around using 1983 to enforce the Nursing Home Reform Act, like the case that just went up to the Supreme Court. But to do that with 1983, you have to have a state actor. It has to be a state-run facility, or the state has to be actively somehow playing a part in the bad action. So if you find those cases, I'm happy to talk to you.
Thanks. Benjamin, did you have any
I think just an interesting point following up from that. A lot of those cases that we talked about before, we are noticing there's a fraud element that in particular jurisdiction that we need to stay away from. And I say that to say, that's why I really like focusing on these claims more the consumer protection element, which isn't a per se fraud element. For example, in the West Virginia case that we're handling, we're basically saying it's deceptive advertising. And we like characterizing that way instead of per se fraud, because when you get to things like fraud, going back to what I said earlier, it gets back into the mental state about what everyone was thinking. So therefore, we're shifting more into a consumer just so it's cleaner, so we don't have to focus on the actual mental state.
Fascinating, thank you. Our next, sorry, good.
Sorry, I would also add that we're trying to focus on getting money back into the hands of the consumers, as opposed to, it's important the government gets its money back too, but we're really focused on trying to get money back into the hands of the people who were duped.
Right, thank you. Regan Bailey, I hope I'm pronouncing their name correctly, asked if you could share the names of the cases And if you can, you can just let us know after the meeting, and we'll post it on the website and share it that
Yes,
way.
I'm
The
happy to
next,
do.
oh, great, thank you. The next question is from Tim Dibble. I'm always distressed on this concept of staffing levels, particularly in light of the Biden administration's proposal to have minimum guaranteed staff levels. What I experienced at my mother's nursing home is that even when there's staff, they are spending their day on the computer or their phones and not dealing with residents. Minimum staffing levels will simply give the nursing home justification to raise rates above the $13,000 a month for more people doing nothing. So it's kind of a comment, but I wanted to read it because I thought it was kind of interesting too. I mean, we hear this a lot. Even the facilities are understaffed, but even then, the staff are not helpful. They're not not always, of course, but we're hearing that situation where they're just not attentive to residents and not doing anything else.
I just opposed my plaintiff in West Virginia, and that's exactly on point with what we're noticing. What's interesting about these cases is that they say that they're staffing them based on care. However, that staffing based on care consists of a lot of other things: cleaning the laundry room, being in the hallway, things that aren't directly supported to care. So therefore, these per se minimums are just really kind of a fraudulent floor because it's really not specific all to care at all. And my plaintiff, same thing. She would see people, the residents on the hallway, on their phone, not attributing to the needs. And what's scary about those situations, they're doing that while she's there, the actual daughter of the resident. So you can only imagine what's going on when they're not there. And therefore spending additional money, like a babysitter, things like that, after talking to our plaintiff, some of those things aren't even options because of the level of trust.
Thank you.
I agree with one of the folks in the chat that
Lisa, you'll need to unmute yourself.
one of the things to think about is it's not just about warm bodies in a building. It really has to be more than that. They have to be trained, they have to be competent, they have to want to be there, they have to be, the idea that people are sitting on their phones just killing time, it's not what it's supposed, that's not what people are assessed to get. They need to have not just warm bodies in the building, they need caring staff who are working to meet their assessed needs. If the facilities assess them as needing X through Y and Z, then X through Y and Z is what they should be getting. And the companies need to not just focus on, do I have warm bodies that are untrained or incompetent or like really hate their job? It's supposed to be a community. And they're supposed to be there. What they're selling is a community where your care needs can be met. So I think it's critical that has to go hand in hand.
Just a brief follow-up of that. And that's so very important. Keep in mind, distinguishable from the nursing care facility, a lot of people and their families, they come in with hope when they place them in an assisted living facility. They think that they're going to get better. They think that it's going to be a transition for the better to hopefully even move them back to the home. And so therefore, I believe that level of hope, and then you see the downfall in terms of their health. For example, one of the plaintiffs in the West Virginia case, even though her mother was 90, when she entered the residence, she was generally fine, walking, driving a little, painting. But because right when she entered there, literally in three weeks, she was in a hospital, fell and broke her arm. So she was only there for a little while. So that just shows the direct impact of not in terms of just not having care, but just peace of mind and state of mind that they're in, dealing with depression, not having that constant contact. So those are all the things that we pay for, thousands of dollars, think that they're going to get that sense of community. And that's unfortunately not what we've been seeing.
Thank you. I just have a quick follow-up. What people have asked me just recently about, taking away the phones of employees, not allowing them to, not taking away permanently, but not allowing them to have the phones on the floor and stuff like that. I don't know if you have any thoughts on that, but if you do, I think that would be great.
I think that's sort of beside the point. If people are not engaged in their work, taking away their phones so they also can't be engaged with their family and make sure their family is safe, that's only going to be a further distraction. What we want is that people feel valued at work and they understand that their responsibilities are to care for the people whose responsibility they've been given. So I think it's, I think that this is a long-standing problem with institutionalization. That somebody just posted, like, they'll just be watching TV otherwise. I think that's true. If you're not engaged in your job and you're not really valuing the people that you have been assigned to care for, I'm not sure that taking away the phone by itself will do it. I think it's really about training and culture change and really holding people responsible, but also giving them the tools. Like, a lot of the people that we're seeing in these cases are themselves in danger. The workers are themselves in danger because they don't have the support that they need. They're working doubles. They're working, so that could mean they're working, you know, up to 24 hours in a facility. That's just horrible. And that is not a way to really professionalize the caregiving function that they're playing. And I think that until we kind of address those issues, I don't know that taking a phone away or taking, you know, or doing other things that are isolating the worker from their own life is going to help. It really is about helping them to feel a part of a team and really feel like their work is valued.
And one of the biggest reasons why we do that in our work is because it's hard to make everyone care about their job. So the reason why we do our work is just to focus on, I know that's almost impossible, but we want to focus on it. So it puts hopefully pressure on people when they're vetting, when they're hiring people, to really select people that really care about the care. Because if that's not going to happen, phones or whatever, that's not going to change the problem. So that's one of the biggest why we're bringing these cases, to put that in the air, even if it's not a concrete injury.
Thanks. And if I may, I would just add in regard to the issue that, especially in terms of nursing homes, there are a lot of very concrete requirements as in regard to having a care team, in regard to having responsibility from the administrator on down for the care that's going on in the facility. So if it is an environment in which people are ignoring residents, et cetera, that really comes from that. And as I said, you know, there's, as we all know, there's not that much in regard to standards for the assisted living and other types of communities, but for nursing homes, there is an expectation that there will be a leadership team that is constantly looking at the quality of care in the facility and services, and doing constant evaluations and quality improvement. It's called QAPI, and it's required under the federal rules now for several years. So that's another way, if you're seeing that, to kind of raise those issues, you know, potentially or preferably, I would say, if you can, with a family council or a resident council, maybe with the help of an ombudsman, to the administration or to that level, so that they're aware. And that triggers their responsibility to interact. So thank you. That was very interesting. So the next question is from Anonymous. I believe there's a class action lawsuit against Sunrise for understaffing. They want to know if you were involved in that suit.
We aren't involved, but it's very similar to our case against Brookdale. Very, very similar. And they just managed to get their class certified in Sunrise. So we're very hopeful that that's, you know, a good turning point, that and their theory is similar to ours, that it's a consumer protection case. They've been duped into coming into a facility on a promise that their assessed needs, that everybody's assessed needs would be met, and it's a false promise.
Thank you.
What's great about that case with the recently issued opinion from the Ninth Circuit, that's similar to our cases that we talked about, you know, the individualized level. The Ninth Circuit specifically said that the residency agreement that all the residents sign can create the implicit reliance on a class level. So that's great case law for these types of cases. And in our upcoming motions, we've modeled it after that theory as well.
Thank you. I'm just going to skip ahead because some of these questions are just a little confusing to me. I apologize. So Sam Kukic, hope I'm pronouncing your name correctly, says, I understand and appreciate what you are doing and also the class action approach. However, what would you recommend to do for all the rest of the residents who don't fall under a class action case? How do residents protect themselves from these lies when it appears to be a standard? People are left as victims to a system that should not allow a facility to take money when they cannot provide a service.
I 100% agree. And so I just want everyone to know that we depend on survey and cert complaints. We depend on them in every one of these cases. So any resident who has a concern should file a complaint with their state survey agency. Because we weave those real life complaints. Those are the voice of the residents for us. We weave those real life complaints all through our papers because that's on the ground stuff. And there are certain manifestations of understaffing, right? There are falls, there are people who are not being bathed, there are people who are developing pressure ulcers, there are people who are having hunger and food shortage issues. There are people who are not getting their medication timely. These are all manifestations of understaffing. And if you all can help us and help all the other attorneys and surveyors even to document those things in real time by making complaints, that's really helpful. And then the surveyors are forced. I mean, the surveyors, as you guys know as well as we do, they're kind of like snooping around in the dark. But if you give them the breadcrumbs to lead them to the understaffing, they can do a far better job and we can hold them accountable to do a far better job, but they need the complaints. So I would urge ombudsman, family members, residents, everybody to file, if they say, if you see something, say something. It's more true in long-term care than it is anywhere else.
Thanks, Kelly. Benjamin, did you want to add anything to that?
And the same thing, like with those surveys, that's really compelling evidence. And even if it might not be from our specific plaintiffs in our class motions, we always include the most egregious things that we find in the complaint, just so the court gets an idea of what's really going on. This is not really coming out of thin air. We're seeing all of the neglect. We found a complaint today where someone was not showered for a year. My plaintiff testified that her mother's teeth weren't brushed for 3 months. So things like that, building on that, that's something that's very powerful, I think, that the court looks at. And you can do that both the class level and the individual level, as Kelly was talking about. But the key is complain. The earlier, the better, and always make your voice spoken.
Thank you. I would just quickly note that if you go to our website, nursinghome411.org, in the Learning Center, we have a bunch of different forms and tools for families and residents and those working for them, including a form that you can use to easily track a complaint that you have. Because again, that documentation is really helpful, doesn't have to be hard, and that is free to use and share. So thank you. Tim Dibble had another interesting question. Many institutional investors in nursing homes assisted living break up the various services that are contracted to this facility for the additional profit of the owner. As for example, the owner owns a property and bills the residents for their bed. The owner also owns a company that provides the food service and takes profit of the fees for the food. Can that be challenged? And I mean, let me just say, I don't think it could be challenged per se, but I'm wondering if you can pierce that, it's not a corporate veil, but you could pierce that to get at the ownership, if that's something that you found you've been able to do.
Yeah, it's about getting to the ownership, but it's also getting to where there's money going. You look,
Right.
We had a case in California where the facility just never, it always lost money. Like, how do you run a business for 7 years where the nursing facility never makes a dime? It's always losing money. So the money's somewhere and you're keeping the business going. So there's some reason you're keeping it going. So we used Ernie Tosh to help us to figure out where did the money go. And we could show where it went, and we could see exactly how it filtered away from the facility to all these what are called related entities. To, in one of our other cases, there's a pharmacy company, a construction company, OT, PT, speech and language, management company. Real estate.
No, we can hear you, Kelly. I can hear you. I don't know. Sorry.
They're all related to the same entity that owns the company, but they have different names. But until you go looking through the cost reports and you then trace up to the cost reports and see that it's actually all the same owners and all the same boards of directors and all the same people who receive service and all the same agents, that's the only way you can see that the money is all just circulating within itself. It's not that they're running at a deficit, they're just siphoning off the money. So Ernie Tosh has done a number of great presentations, one with Sam from Consumer Voice. They're up on Consumer Voice's page to sort of look at how you figure these things out. But you're right, this is a huge problem, and it is it's the way that the industry has been allowed to progress since Manor Care started buying up facilities and breaking the facilities away from the real estate around 2008. And, that's the whole reason that the Nursing Home Transparency Act was created, is because we couldn't even see who the companies were before. At least now we can see some semblance of who the companies are, but we still can't stop them from siphoning off the money.
Just as a reminder, we're going to have Ernie at our next program next month. He's really a terrific speaker. Also, because you mentioned California, we actually were co-authored a study in the Journal of American Geriatric Society, published, I think it was in April, on California nursing homes and their profits. And it showed that the profits actually went up during the COVID pandemic for nursing homes, even though a lot of nursing homes were claiming that they were, losing money and hit hard by the pandemic. So yeah, thank you for that. I know, Benjamin, if you wanted to add anything, we can go on.
I don't have anything more with that point.
Thanks. Let me just see how much time. So we have another minute or two. Oh, here's an interesting question from anonymous attendee. If you signed an arbitration agreement, how can you opt out?
It's almost, our arbitration agreements are very, very difficult to opt out on. We've been seeing that a lot. So the only way to opt out is initially, once you sit down with that resident, if you see an arbitration agreement, you can choose not to sign it. But at that point, it's typically a condition. And just unfortunately, just the way things work, it's going to be an implicit part of almost every agreement, in all types of matters. So you can opt out, but practically that will only do so much, and they would probably not let you enter the facility.
I will say that that's illegal, though. If there's a barrier in the law called an adhesion contract. And if you condition your admission on somebody signing an arbitration agreement, it is in fact illegal. So if ombudsman, family member, residents know that a facility is doing that, they should report them to the state immediately, because you should not ever be allowed, a facility should never be allowed to condition someone's admission on coercion. It's basically coercion. Either you sign this agreement or you don't get in. But I think that until we start catching people red-handed at this, I think it's going to continue. But to Ben's point, though, it literally, when you see the agreement, you can just X it out. And like many of our plaintiffs are plaintiffs in our lawsuits because they X'd out the arbitration agreement. That's why we have them as plaintiffs, because they refused to be bound by those agreements, and they still got into the facility.
Thank you. That was actually the next question I wanted to ask. So just two very quick, hopefully quick questions, if I may, and then we'll wrap it up. One is from an M. Lamb, who asked, you are at the federal level. When do cases have to be brought locally rather than federally?
We bring a lot in the state court too. The California case I was mentioning was in state court. The Illinois court case is in state court. So and actually the West Virginia case started out in state court, and the dumb defendants moved us to federal court. But we usually, because the state law on a lot of this is better than federal law, consumer protection statutes, for example, are at a state level. We usually do bring them at the state court level, but a lot of times defendants don't want us at the state court. They want us at the federal court, so they move us. So I do think it's critical that we bring them at every level. Like, let's just have as many of them going as we can.
Thank you. Benjamin, did you want anything? And then we'll just go one more question.
And that is, it just brings us as we can, like the laws are typically better in the state, but I think that what I'm finding just in terms of practically, the judges in the federal courts are just sometimes, I'm learning, more knowledgeable about certain situations, especially when dealing with class in terms of damages. So I say that even though we filed our West Virginia case in 2016, it's better now that it's in federal court because it's basically the rocket docket. So that, eliminates a lot of frustration, a lot of timing. So that's one thing that I personally love federal court for that reason. But Kelly is absolutely right in terms of at the state level, the laws are better. So we have to bring them everywhere.
Thank you. And then last question from Rosemary McDonald Harita. What protections are there for residents who are undocumented or have felonies that prevent them from accessing housing in their community?
I think that the protections are few and far between, not just for the residents, but also for workers who are immigrants. I think that this is an area that requires a lot more study and work to make sure that people are not being isolated because they could be more easily victimized because of their immigration status. And I think that that's, I think that's a really big problem. And I think the protections, there are, in some states, I think that's better than others, but there are immigration protection places that have nothing to do with long-term care that I think people should consider reaching out to. I don't know any of them off the top of my head, but maybe between Richard and I, we can help come up with a list of those. But I do think there are, it's a big consideration. I think both for there are a lot of workers being pushed into long-term care involuntarily because somebody's holding their visa and they are forced to go work at like pennies on the dollar. So I think it's both sides of the equation, definitely the residents and also the workers.
Thank you. Kelly and Benjamin, thank you. This was really excellent and so interesting and engaging. I really, really appreciate all the work you do, as well as for joining us today. Again, everyone, thank you for joining in the audience. This recording will be up at the end of the week. And have a nice afternoon, everyone.
Thank you guys so
Thank
much.
you. Thanks so much.